Hey guys, how are you? So this is the editorial analysis of newspapers for today. That is 27th of January 2017 and will be presented to you by me, Dipanshu Singh. So you can go through this slide for more information about me. This is the agenda for today. We'll be covering these articles. And answer writing practice question for today is regarding the universal basic income. So click on this bubble to go to the Unacademy discuss page. In case you don't know, where is the discuss page, and answer your question below the thread. And we're actually trying to make a review committee to help you guys with the reviewing the answers. And so we are working on that. Please bear with me if I'm not able to review your answers daily, but then obviously I'll keep giving you my inputs. So apart from the articles which we'll be covering today, these are the two interesting articles which you can go through for some insights. And so the first article talks about the Ordinance Raj, so continued and repetitive misuse and abuse of power by the central government and the state governments by issuing an ordinance goes against the principles of our constitution and the ideals of our founding fathers regarding the Constitution of India. So the Supreme Court recognized that the power to make ordinance has been abused to subvert the democratic process. This is in context of the recent case in Bihar, Krishna Kumar Singh versus State of Bihar. So a series of pronouncements were made by Supreme Court which can have a potential huge implication. So the Supreme Court said that the failure of a legislature to confirm an ordinance and was fatal both to the validity of the law, and at the same time, unless there is a need of a public interest or otherwise demanded, it also subverts the rights and liabilities that have been accrued from such a law. And so according to Justice Chandrachud, he said that the authority to issue ordinance is not an absolute power or an absolute entrustment, but is conditional upon the satisfaction of the need and the circumstances to issue the ordinance. And so therefore ordinances are not immune for judicial challenge or judicial review. So what are the issues regarding ordinance? So the founding fathers of our constitution aimed that it will be used to impose a separation of power between three recognized wings of the government. So the legislature or at the center, at the state, both are tasked with the primary job of making laws. The executive's role is obviously implementing these laws, and the judiciary's role is to interpret the laws and to check whether they follow the constitutional provisions. But then the role of executive is now more towards issuing ordinance, so they are actually going beyond their powers by repeatedly misusing it. So it goes against the general grain of command, and it neither acts as a check nor as a balance on the authority exercised by the other branches of the government. And Dr. B.R. Ambedkar, initially when there was a heated discussion on this issue in the Constituent Assembly, said that the provisions of the ordinance ought to be used as a power to legislate when the parliament is not in session and where the critical and a dire need to do so. But then if he would have been alive at this time, he would have been surprised to witness the systematic dismantling of the constitutional basis of the ordinance making power by the recent governments, both at the center and the state level. So the very problem is at the very root of the powers conferment. The provisions of the article in the constitution needs to be amended because they allow the power to make ordinance which are repeatedly misused by the government. So which has to be used in exceptional measure is actually being used repetitively. Under the Article 123 of the President is empowered to make the ordinance with the consultation of the Council of Ministers, and further it will cease to operate. This is just a revision of the polity concepts, that the ordinance cease to operate at the expiration of 6 weeks from the reassembly of the Parliament. So I have a question for you guys. Just let me know in the comment section below what is the maximum the period or a life of an ordinance before that it can survive. And if the Parliament also, before the time of the conclusion of the period, passes a resolution disapproving the ordinance, so the ordinance ceases to exist. So it's the same provision that's the power given to the governor of the state under Article 213. But then, however, in practice, that we all know that ordinance have been scarcely been used as a purely exceptional measure. And most recently, the central government actually issued repetitive ordinance in the case of the land acquisition law, and the aim was obviously clearly to bypass the parliament because it didn't have the numerical strength in the Raj Sabha. So therefore, it was virtually using it as an alternative tool of legislation. And the present case is regarding a series of ordinances which were passed by the Bihar government regarding the 429 Sanskrit school. So Justice Chandrachud in this said that not only the repromulgated ordinance but the original ordinance issued at the first instance concerned is subject to judicial review. For this, he relied on the celebrated S.R. Bomai case of 1994, and he also said that the courts can investigate to see, in spite of the material evidence, whether there has been either a fraud or an abuse of power committed by the executive. Very important line which can have huge implication in the future, and it will have a far-reaching implication, because the first time they said that they actually went over and overruled two of its earlier judgments, and they laid down the theory of enduring rights, where it said that the ordinance is distinct from a temporary legislation, because it does not automatically create rights and liabilities that can go beyond its terms of operation or its life. So he also said that the courts must examine whether the undoing of acts performed under an ordinance would run counter to the public interest. So this is basically, once the ordinance ceases to exist, the acts done at the time by the government or the executive, whether once it is repealed or rather it ceases to exist, the provisions made under that the orders taken by and the will run counter to the public interest, but this provision is a little dicey, because a test of public interest could prove somewhat problematic in the future, because there will be a lot of cases where the outcomes are manifestly irreversible, where it cannot be undone, but then, however, in spite of that, the court's verdict is to be seen in placing as a vital check on what until now has been a power rampantly abused by the executive. The next article is about the Insolvency Code, a very important article. It talks about what are the present issues in implementing this Insolvency Code. So this was brought into with the provision for the time-bound resolution of insolvency and bankruptcy, and obviously for a speedy exit from the failed investments. So the first insolvency case was filed by ICICI Bank Limited against Pune-based steel makeover innovative industries. In the National Company Law Tribunal. So there are obviously two bodies who will deal with this insolvency issue. For companies, it will be NCLT, and for individuals, it will be the DRT, that is the Debt Recovery Tribunals. And the code also provides for a time-bound resolution, but the lawyers and analysts point out that there is a huge pendency of cases that will pose a challenge for this quasi-judicial institution. And the code also seeks to reduce the time of the resolving an insolvency process to less than a year, which earlier used to take 4 years. And if you go by the recent report by a firm, it said that it might take more than 7 years to clear the 25,000 pending cases it received as a legacy from the previous body. And it also questioned about the supporting infrastructure, whether it is in place adequately or not. So the government has finally set up the regulator, which is the Insolvency and Bankruptcy Board of India, and had appointed key functionaries. But there are still issues regarding the guidelines. There are no proper guidelines, and also there are issues. The main concern of investors looking into Invest India was the speedy exit from failed investment. That has to be addressed as well. And it was also aimed at addressing the problem of rising bad debts in the Indian banking system, that is the NPA issue. Apart from that, there are other concerns regarding the 9 members of the board. Only 3 were to be whole-time members, and also 2 were of the government and 1 from the RBI. And other concerns are there is still continued interference of the government, flawed regulatory framework, absence of cross-border law, absolutely illegitimate approach to personal insolvency lawmaking, and the extent to which the DRTs have been given jurisdiction. So to improve all this, there has been one measure. The government is actually trying to set up an eDRT to shift most of the paperwork online, which will actually help in ease of doing business ranking of India. So apart from that, two important point here, which are important from prelims point of view, are the role of DRT and NCLT. So DRT will be adjudicating both individual and limited liability of partnership firms, and NCLT will deal with the cases regarding the jurisdiction over companies with limited liability. And if you look at the graphs, the number of pendency and the huge burden of pendency of cases is going to increase all over, and the estimated, as I told you, is 25,000 cases which are pending. So this other article is about the Syrian peace talks, which were concluded in Astana in Kazakhstan. So major superpowers came to the table, and actually the Syrian government and the armed opposition came to the table for the first time in 6 years. So this is kind of an important article, but try and understand it, because there are a lot of issues and connecting points in this. Things will get more clear once the talks have been shifted in Geneva. So in spite of all the efforts, there were concerns over the lack of external support. So the major proxies of the armed opposition from Saudi Arabia, Turkey and US, obviously these are at loggerheads. So they are at one side and the Syrian and the Russians are at the other side. The Turkey had decided that this war has already reached over its territory. There is an issue of the Kurd rebels, entering their border, and then Saudi Arabia also is stuck in the Yemeni issue, the issues with Yemen, and finds that its proxy can no longer compete with Russian air power, because Russian air power has been really the game changer in the Syrian conflict. And the US, which had actually failed to create a modern army, understand the fact that its most capable fighters are not trustworthy anymore. So the principal dispute is how to define the ceasefire and how to go about this ceasefire. There are certain issues regarding it. First is that the armed opposition led by Mohammed Aloush of Saudi Arabia's proxy, Jaish al-Islam, they wanted a national ceasefire. However, the Syrian government, the Iranians, are keen to remain effectively at the local level. And apart from that, two important parties are outside the ceasefire, that are the Islamic State and the Al-Qaeda's proxy, Jabhat Fateh al-Sham. So these groups have already tried, and they're attempting to peel away fighters, and they're trying everything to attract fighters towards them, because on the basis of that the negotiator is actually shaming the revolution, the so-called Syrian revolution. And the JFS has also identified its, intensified actually its retaliatory attacks against the rebels, and there US airstrikes was also continued. But the Turkey has made it clear that in order for this bloodbath to stop, they need to isolate JFS, which is trying to attract and mold other and appeal other members of other fighting groups. So there's a serious issue, there is a serious conundrum for the Syrian government, even though they are buoyed by their victories. Notably in Aleppo, there are serious concerns with them, because their military is weakened due to the continued conflict, which was demonstrated by the fact of the rapid advance of ISIS into Palmyra and Deir ez-Zor. And apart from that, from the issue of dealing with ISIS and JFS, the Syrian government will have to deal with two other problems, that is the disgruntled Syrian Kurds, where political aspirations have been suppressed as a cost of Turkish involvement, and the other is obviously the Islamist armed opposition who came to Astana but refused to describe Syria as a secular state. So this peace process will take time, and peace is a process and not a state. And obviously the negotiations have moved to Geneva, where the UN hopes that more progress will be made, and even the Syrians hope that there will be some progress on this. So once this peace talk takes place over Geneva, in Geneva actually, we will get to know more about this and will update you further. The other is regarding an important article regarding disaster management and how to go about it. So this is an example which was taken, and a model which is implemented, which will be implemented in other parts of the world, replicated in other parts of the world, from the Bhuj earthquake, which occurred on 26th January 2001. So this year it was its 16th anniversary. So how was it made possible? First of all, everybody thought that the rehabilitation and reconstruction work will take a lot of time, but then Bhuj has emerged as a strong city after the disaster. So in Bhuj rebuilding, the Gujarat approach is widely looked as a model for reconstruction. From it was even implemented in Nepal's earthquake, and after the Kashmir earthquake, for rehabilitation. So it's boasts for a high-rise apartments, sprawling supermarket, beauty salons. Then there are aid workers, global experts, people from all denominations living in Bhuj today. And there's development of banks and state governments have invested vast sums in the infrastructural development. So therefore, the land has become an attractive investment. But there are certain issues with that. The first is that the public roads, therefore, to improve the public transport, the Bhuj roads were widened, which affected the livelihood of the hawkers, which were evicted and removed. Then 60% of the population did not receive their compensation from the government, and earlier these residents wanted the regularization of the pockets, but there was no action taken. Apart from that, there are some issues of the communities which were driven out on the pretext of encroachment. The other issue is the relocation of villages has been done on the agricultural land, and then there is obviously shortfall of revenue. So the village and local governing bodies and NGOs, they played an important role, but then they haven't been empowered as much as they wanted to with the lack of financing. So areas of concern, there are a lot of areas of concern. Rehabilitation package announced, were offered unequal treatment. The size of the agricultural land was also adopted as one of the criteria for assistance given. So people who got assistance and compensation was based on the pre-earthquake house sizes, which actually effectively meant the richer people were likely to derive larger benefits. Then relief provision also accorded were completely collapsed houses in urban areas and then rural locations. And post-disaster development planning also completely ignored the entitlements and the right of the individual. So the entitlement of the land for the urban poor who performed important function was critical. By changing such settlements, development actually snatched away entitlements of these people. There were expensive public land in Bhuj has been given to better off people, and the land inhabited by the poor in Rabri were actually acquired for government offices. So in all, it sums up that the Bhuj example actually shows that disaster management practice in the country remains highly technical and instrumental, and the current model does not have any effective policy framework to address social exclusion and the marginalization of the poor. So you can link this issue with the Sendai framework for disaster reduction, which was adopted by India as well. Recently, it was in news, and it was adopted at the third UN World Conference on Disaster Risk Reduction, and it is a non-binding agreement, which is a successor to the Hyogo framework. So this can be asked in prelims as well. So you can use these points to add on your notes and how disaster management should have been taken about, and how to address these issues. So till next video, I hope you have a good day, and thank you so much. Bye bye.